Hi there. My name is David Merrill, and I'm a bankruptcy attorney in West Palm Beach with the firm of Ozment Merrill. We're a bankruptcy firm that handles Chapter 7s, 11s, 13s, and 12s, and we're involved with most aspects of bankruptcy law in general. In addition, I also handle cases that are called adversary proceedings, which is a lawsuit in the bankruptcy court, and have had this practice, even though we're based in West Palm Beach and have an office in West Palm Beach. This practice is one that I enjoy throughout the state of Florida, and in fact, throughout the southeastern United States. While my partner Drake Ozment handles matters that involve consumer cases such as Chapter 7s and 13s, my practice is focused primarily on Chapter 11s, where you'll see sometimes it's individuals with complex business matters, but very often what we're dealing with, and more often, are businesses. And our firm has handled matters that, in the construction industry, real estate, manufacturing, healthcare, mostly privately held companies, but also publicly traded companies as well. Chapter 11 bankruptcy is what's known as reorganization, and that word by itself might be a little confusing in light of what people tend to think about what bankruptcy is. So I'm going to take a brief moment to explain all of the chapters in bankruptcy very briefly so that you understand 11 a little bit better. Most people think that there are only 1, 2, maybe 3 chapters in bankruptcy. In fact, there are 6 chapters available to people who are considering bankruptcy as an option. It just happens to be that 3 of them are chapters that most people don't participate in very often. One of the ones that people know the least about is something called a Chapter 15 bankruptcy. Now, 15 is an international cross-border case that deals with insolvency between one country and another. It's nothing that most people need to deal with. If you want to know more about Chapter 15s, schedule an appointment with us. We'll be happy to go into detail about that. But that's a very complex area of the law, very related to Chapter 11s, I might add, but they travel under their own rubric with respect to how the rules work, and sometimes there are international treaties involved, so we don't want to boggle our minds too much with getting into Chapter 15. Chapter 9 is another chapter that some people may be more familiar with now. Chapter 9 is for cities, municipalities, and has become much more widely known lately due to the Detroit bankruptcy. That was a Chapter 9 case. Chapter 9s are extraordinarily rare, and unless you are a city, you don't really need to think much more about a Chapter 9. Chapter 12 is a case that we do handle here in our office. Chapter 12 is for family farmers and fishermen. It's a very fascinating chapter for use not just by individuals. You can actually be a fishing operation or a farming operation, but there are a lot of specific rules that are required in order to be able to get involved with it, and we would certainly need to make sure that before you considered that that's the right way to go. I can rest assured that just because you're out fishing every day doesn't mean you qualify for that particular chapter. So at any rate, let's talk about the 3 chapters that are much more common. That's Chapters 7, 11, and 13. Chapter 7 is liquidation. And in the context of liquidation, what we're talking about is a process that I'm going to explain briefly in a fashion that sounds very, very scary. And then I'm going to explain it in a slightly different fashion just so that you understand how the various laws interact with one another. Now, Chapter 7, the theory is they take a snapshot of a day in your life. We're talking about all of your finances, all of your assets, which are the things that you own, and all of your liabilities, which are the things that you owe. You have to disclose all of these, and I need to be very, very clear about this. People love to say, oh, well, I owe my mom a couple of bucks. You got to put her in. You have to include her. There's no skipping around with this type of thing. It's an all or nothing type of situation. So all of your assets, all of your liabilities. Now the theory, and this sounds scary, is they take all the stuff you own and they sell it. And they use the proceeds from that sale to pay your creditors as best as they can be paid. Anybody who doesn't get paid gets discharged. That's generally how the theory works. Now discharge, that's a word people don't use every day. What it really talks about, people think of it that it means that your debts have been erased. That's not legally accurate because they're not going anywhere. But as far as you're concerned, your liability to have to pay those debts has been abrogated. So as a practical matter, if you think about it as being erased, that's not a bad way to consider it. Now, let's go back to that sale of all your assets that was so scary. The reality is that there are these things called exemptions. And Exemptions are laws passed by the U.S. government and the Florida legislature that essentially say, look, there's a certain amount of stuff that you're allowed to keep so that you can go forward and be a productive member of society. Most people in Florida, and Texas for that matter, are familiar with their homestead exemption. Now, I need to be very careful about exemptions. You can't just move to Florida and get a 100% exemption. There's a lot of detail that goes into when you're eligible for Florida and when you're not, and when you're eligible for federal and when you're not. And that's something that we really need to sit down and talk about with you in a personal consultation. The bottom line, though, is there are about 18 different types of exemptions and subsets of those as well. The bottom line is that in many cases in consumer matters, those exemptions are sufficient to protect all of the assets that you own so that nothing ends up being sold. Because nothing is sold, everything gets discharged, and that's the great result. And that's your typical situation in a Chapter 7. As one aside, something that confuses a lot of people, businesses, even if they file a Chapter 7, are not entitled to a discharge in a Chapter 7 case. They're entitled to something called a permanent injunction, which is practically speaking very, very similar, but it's not quite the same thing. And that's something that you certainly need to be aware of as you're thinking about what's the appropriate chapter for you to decide to take. Moving along to Chapter 13. Chapter 13 cases are limited. They used to be known colloquially in bankruptcy circles as mini 11s. Prior to the time that they were codified in 1978, you would try to take a Chapter 11 reorganization and fit it onto an individual situation. And why would you do that? Well, in Chapter 7 cases last about 3 to 5 months typically. They can last as long as 2 years. But the bottom line is that what happens if you have fallen behind in your home mortgage payments? Well, a Chapter 7 case doesn't erase the amount of debt that you were owed prior to filing the case. You still owe that. Well, how's that going to save your house? Well, in a Chapter 13 case, basically you take that amount and you spread it out over a 5-year period of time, almost always interest-free. If someone's owned a house for a very long time, it might not be, but that's a rare circumstance anymore. And the bottom line is that you can then make your regular payments, and you can get caught up on your Chapter 13 payments, and it's a great result for you and for the bank, frankly, because you're able to get caught up in a fashion that under their guidelines and under the regulations that they have to abide by, they wouldn't ordinarily be able to agree to, but there'll be a court order that requires them to, and that's a great result for everyone. Interestingly enough, in Chapter 13, sometimes that's an appropriate chapter to file in a situation where, as in a Chapter 7, there aren't enough exemptions to protect all of those assets. So what you end up with is a situation where instead of losing those assets in a 7, you can pay for them in a Chapter 13 case. Now that's a great result as well. You get to keep those things that you have a lot of attachment to. Perhaps it's a family heirloom. Maybe you've got a baseball card or something, a baseball card collection, I should say, that you like. But you don't have to have that sold just because of something that occurred in your life, like perhaps you got in an accident or there were medical issues or whatever the situation may have been. But you also don't have to be unfair to creditors and not pay them at least the value of what that would have been. So that's a situation where 13 is used as well. Now, I mentioned earlier that 13 used to be called a mini 11, and in many respects it still is. This is because in Chapter 13 there are limits to the amount of debt that you owe. The bottom line to those limits is that if you exceed them, then you need to be in a Chapter 11 case. Now, before I go into a Chapter 11 in more detail, I should also point out that since 2005, some people who earn substantial income are no longer eligible to file a Chapter 7, and they are required to file a Chapter 13 and use their income and earnings to be able to pay creditors back more than they would have been paid in a Chapter 7 case. That's something that we can go over with you in your free consultation with us, but it's also something that you should be aware of, at least in becoming more knowledgeable about what bankruptcy is all about. Now, Chapter 11, by contrast, is very different. One of the big differences between 13 and 11 is that in 13, not only are you limited by the debt, but you're limited by the term of years within which you are allowed to be able to repay your debts. Typically, a Chapter 13 case goes for 60 months. That's a 5-year plan. There are circumstances where it can be as little as 3, but pretty much set your expectations for a 5-year plan. Now, a lot of people say, great, I don't want to be in bankruptcy one moment longer than I should need to be. And quite frankly, that's exactly right. But there are circumstances where you may need more time in order to be able to reorganize the debts that you have so that you can then be able to go forward and be a productive member of society, or perhaps more importantly, if you're in a business, to be able to save all of your employees' jobs and to remain a viable entity. In Chapter 11, there is no technical limitation on the amount of time that that you might be in a Chapter 11 case, or that you might make payments in Chapter 11. There are a lot of interesting and technical deals with 11, but ultimately what you're talking about is, first of all, individuals can file Chapter 11. One of the more typical things that we still see today is a situation where an individual or his family owned a business, and it was doing amazingly well in the last business cycle. And they used the profits from the business to buy houses. Those houses, then they put debts on and got mortgages to buy more houses, and now they've got 10, 15, 20 houses. And the problem, of course, is that, of course, the housing bubble happened, and now they can't pay for those houses because the rents that they were earning simply isn't enough to be able to pay the debt service. Well, what do you do if they're going to lose those houses? Then they're going to lose the business because the bank is going to want to get all of the extra money that would be owed to them paid somehow. Now, that extra money is usually known as a deficiency. And you think of that this way. If your house is worth $100,000 and you owe $150,000, well, you're upside down by $50,000, and in that circumstance, that $50,000 is what's known as a deficiency. Well, what you can do, and I need to caution you with what I'm about to say, because there are different rules with what's called your primary residence. In Florida, sometimes people call that your homestead. There's sometimes a distinction between primary residence and homestead. That's rare, by the way. It's almost always the same thing. But the bottom line is that that amount of money, if it's your primary residence, cannot be treated in the bankruptcy in the way you can treat non-primary residence debt. And I'll give you an example. Let's say, for example, you've got that $100,000 home, and you have a $150,000 mortgage. You've also got on top of that a $50,000 second mortgage on that property. Now, there's two concepts here. There's the strip off and the cram down. And I'm using some colloquial language here because in reality, in Chapter 11, it's not really a strip off per se, but that's technically how it works. That's a term that's used a lot in Chapter 13 types of cases. But we're going to use that because the technical operation of what's going on is essentially the same, or I should say that the net result is essentially the same. What you would do is you would say, look, bankruptcy court, I've got a $100,000 house. Here's my appraisal. Here's my value, and it's $100,000. And you may have a trial, and the bank may argue with that, but at the end of the day, you'll come up with a value. And for this example, it's $100,000. Because not $1 of value on that $50,000 second mortgage is actually attached to the house, you can strip that off of the mortgage or off of the house so that it is no longer a lien on the house at all. It's just been removed, and it is treated as a general unsecured debt, kind of like a credit card. There are different types of debts, and we'll talk about that in a minute, but that's ultimately what we're talking about is you're treating what used to be a mortgage like a credit card in terms of the liability. Now, if it's not your primary residence, the other thing that you can do is called the cram down. You can actually say, Judge, I would like to have that $150,000 loan now be a $100,000 loan. And the technical term is bifurcation. But essentially what happens is that $50,000 also gets treated as a general unsecured debt. So you're left with a $100,000 house on which you owe $100,000. Now, what's beautiful about that is that then you can negotiate with the bank and work things so that you can modify that mortgage, and respread that over 20 years, sometimes 30 years, in rare instances as long as 40 years. Different lenders have different underwriting guidelines within which that they operate in order to deal with those types of situations. And in the context of Chapter 11, there is a way to force that to occur so long as you have the votes, and I'm getting into a lot of concepts we haven't talked about, but to be able to confirm your plan. I want to go back a moment and explain that in Chapter 13, getting a plan confirmed is solely about complying with what the bankruptcy code requires you to comply with. So long as you comply with it, your case will be confirmed by the bankruptcy court. In Chapter 11, you can comply with the code in full, but your creditors have an opportunity to vote on your plan. So it's important as you go through the process to understand that while you're going through valuing property and stripping mortgages and doing all of these apparently wonderful things, they have several bites at the apple after that within which they can come in and say, wait, we don't want to be treated that way. And this isn't the forum for going into all of those details, but in addition to voting, they also have something called an 1111B election that they can make, and there's a lot of vagaries that are involved with when they take that and what it's worth and how that works. We don't want to confuse you too much with all of that detail in this conversation, but understand that there is a real back and forth in the Chapter 11 process that doesn't exist in Chapter 13. So a lot of times if you're able to go in 13, it is advantageous to do so. Again, however, if you're going to spread a mortgage out with that cram down that I mentioned moments ago and try to get something spread over 20 years, 25 years, 30 years, whatever it is, you can't do that in a 13, which is only limited to 5 years. So that's a circumstance where you may end up realizing that Chapter 11 is the place that you need to be if you have a lot of property that you need to be able to value and to modify how you're making payments. So those are all of your chapters. Those are a lot of the types of things that we deal with respect to Chapter 7, Chapter 13, Chapter 11. In the context of business reorganizations, Chapter 11 has a lot of very powerful tools similar to the cram downs and also strip-offs, but in a more commercial sense that we use. There are a lot of ways that you can ensure that you're paying your critical vendors in a fashion that's appropriate, and really just a lot of different things involved with all of those elements. Very complicated stuff, to be sure, but also very manageable as long as you've got competent representation. This is David Merrill again, and I wanted to take a moment to thank you for taking the time to look through and watch the different information that we have for you on Chapter 11 and other chapters in bankruptcy. Drake and I at Ozment Merrill are happy to talk to you about any of these matters, and in fact, we offer an initial consultation that is free and would invite you to call us at 561-689-6789 at your convenience. We'll be happy to meet with you and talk about whatever the specific situation that you're facing is. Have a great day.